Azeltine, I may be pronouncing that wrong, is had a fairly recent warrant. If we're comfortable addressing that on the record.
Yep, Mr. Azeltine, are you able to turn on your microphone?
Can you hear me now?
Yes, sir. Okay, it looks like you missed your hearing on July 16th, just a few days ago.
I am, without recourse, sui juris, in propria persona, the living man, and not representing the incorporated Ty Warren Azeltine entity. I am the affiant of the affidavit of truth filed in this case, April 26th, appearing specially and not generally under threat, duress, and coercion to correct the mistaken identity misnomer of the defendant, and notice this court to dismiss this case sui sponte for failure of joinder, failure to serve the complaint, failure to state a claim upon which. Has someone entered a plea on behalf of the defendant?
All right, I'm not going to be able to address this case unless I have assurances that the defendant, Ty Azeltine, is the person here, and I'm hearing a lot of nonsense that doesn't address directly, that rather obfuscates the clarity on who you are. If you're not Ty Azeltine, then you're a spectator and you're welcome to stay. If you are Ty Azeltine, I'll address your warrant, but I will address no other issues in this hearing because this hearing is limited to quashing warrants and setting court dates. So are you Ty Azeltine?
Does the caption of this case not say Ty Warren Azeltine in all capital letters?
Your Honor, I can speak with Mr. Azeltine in a breakout room if you prefer, or.
Well, he's not represented by counsel and hasn't been throughout this case.
He's refused counsel.
Yep. If you're Ty Azeltine, just tell me that. If you're not, then I'm going to let you spectate for the rest of the court calendar until we're done.
I am the affiant of the affidavit of truth. And if you look at the affidavit, it will clarify who it is that I am. There are two.
Okay. All right. I've muted your microphone. It appears to me that you don't claim to be Ty Azeltine. So I'm going to strike Ty Azeltine's hearing and the matter will be, the warrant will be left outstanding. And Heidi, no one is eligible to appear on Zoom in this case. They have to apply in person for a warrant quash. All right, and sir, you're free to remain and watch the rest of the calendar. We're going to go on to other people.
Welcome to the Courtroom circus. And today, we've got not one, but two self-proclaimed sovereign citizens who insist they don't belong to any government, any system, or apparently any realm of logic. This is the kind of hearing that starts with confusion and ends with pure chaos. Both defendants claim to be living men, a phrase that's become the battle cry of people who believe the law only applies if you accept it. Spoiler alert, it doesn't work that way. In this video, you'll see judges at their calmest and defendants at their most delusional. From pseudo-legal babble to biblical levels of denial, these moments prove one thing. Courtroom logic and YouTube law degrees don't mix. Let's dive into the madness.
This is people of the City of Royal Oak versus Anthony Winston Mathis. Mr. Mathis, are you available?
Yep.
Good morning.
Grand Rising.
You are Anthony Winston Mathis?
No, I'm Anthony Mathis, the living man, here in special appearance for Anthony Winston Mathis, also acting in my proper capacity of the trustee.
The citation before the court, Mr. Mathis, indicates that on May the 24th of this year at approximately 9 p.m., you were operating a 2024 Ford Edge, black in color, on 11 Mile Road, air near Washington, in the City of Royal Oak. And at that place and time, you committed the civil infraction of impeding traffic. Impeding traffic, sir, is considered a lesser included offense within nearly any moving violation. And Officer Moran indicates in his detailed note that your vehicle was on East 11 Mile Road at Washington and disobeyed the traffic signal. The officer had a green arrow and therefore driver had a red light. Mr. Mathis, you have three options and three options only, sir, in the protection of your own rights. You may, sir, admit responsibility in this matter. The court will attach the scheduled fine and that will close the case. Or, Mr. Mathis, you may admit responsibility with an explanation that you believe mitigates these circumstances, or you have every right to deny responsibility and the court will swear the party.
If you've ever wondered what courtroom word salad looks like, this is it. What we're hearing here isn't a language problem, it's sovereign citizen speak. They love throwing around Latin terms like sui juris or in propria persona, as if reciting a magic spell can erase legal responsibility. But here's the truth. Those phrases have legitimate legal roots, just not in the way these folks use them. Judges hear this all the time, and it's usually the first red flag that the hearing is about to turn into a philosophical TED Talk no one asked for.
And we'll take testimony. What would you like the court to do for you today?
Well, I have a few questions, if you don't mind.
The court does mind. You need to make a plea. I am required by
No,
law.
I don't plead to anybody. I only plead to the Most High. Who are you?
I am Magistrate William Urick, P43273. I am a sworn judicial officer of this district. We are here for your informal hearing that you requested. This court is required by law, procedure, and court rule to take a plea. The motorist requesting this informal hearing, that being you, must make such a plea. You may admit responsibility in this matter.
I don't plead to anybody but God.
You may admit with an explanation, or you may deny responsibility, and the court will swear the parties and will take proofs. What would you have the court do for you today?
I don't plead to anybody.
Very well. Officer Moran,
And there it is, the word that every sovereign citizen tries to dodge. Jurisdiction. The judge breaks it down perfectly. Jurisdiction isn't optional. It's established by location, date, and event. You commit a violation in Thurston County? Guess what? That court owns the case. The more these defendants argue against it, the more the judge's patience runs thin. You can practically hear the years of experience in his tone, calm, precise, and completely immune to the nonsense being thrown his way.
Magistrate, on May 24, 2024, at approximately 9 p.m., I, Officer Moran, was in the area of East 11 Mile in Washington when I observed 2024 Ford Edge black in color with Michigan plate Edward John Lincoln 6501. I was at the light at East 11 in Washington when I had the green arrow to turn. That vehicle then proceeded through the light. As I looked up at the traffic light, that light was red for that driver.
very well. And with respect to your selection of citation, you elected to simply issue a ticket for impeding traffic. Is that correct?
I did, magistrate, at that
And
time.
that's based on your discretion, your training, and your experience.
It is.
Thank you. You obviously have the right to rebuttal if you choose to use it, Officer Moran. Mr. Mathis, it is now your turn. What would you like the court to know, sir?
So I have a question. Are you a judge?
Mr. Mathis, the court has already indicated it is a sworn judicial officer. It is exercising its jurisdiction lawfully over you. So questioning the court's authority.
You don't have any jurisdiction over me. I would argue you don't have any jurisdiction. Okay.
Mr. Mathis, the officer has already testified as to the facts of the case. It is now your turn to testify. You can tell the court anything you wish the court to know, focusing solely on the events of the date in question. What would you like to tell the court?
The plaintiff is the city of Royal Oak. Please bring the city of Royal Oak. Where's the city of Royal Oak?
The officer is representing the city of Royal Oak, sir.
Where's the city of Royal Oak?
Are you asking where it is geographically, or are you asking where it is in
right
terms
now
of who's present?
You know it's bad when the judge hits mute faster than a Zoom meeting gone wrong. This is the moment where logic meets the mute button. The defendant is trying to argue his existence, while the judge just wants to confirm his name. The irony? The judge is actually giving him every opportunity to clarify his identity, something any normal person would do in 5 seconds. But instead, he's doubling down on a belief that he can opt out of reality by word choice. Spoiler, reality wins every time.
The officer is representing the city of Royal Oak as a sworn and certified Michigan peace officer. So what else would you like to tell the court, Mr. Mathis? And please, again, the court suggests that you focus on the events of the date in question.
Okay. Well, could you please bring forth the injured party? Was anybody injured?
This is not a tort case, Mr. Mathis. It is a case written
Well,
under the motor vehicle code
as I
of the
was
city of
traveling,
Royal Oak as it is adopted.
as I was traveling, the officer turned on the lights. No one was injured. So please bring forth the injured party. Based on the Constitution, the Sixth Amendment right, I have a right to face my accuser. If the plaintiff cannot come to court, then this shall be dismissed. That's failure.
Mr. Mathis, is there anything else you wish the court to know?
Please bring forth the injured party. If you can't bring forth the injured party, then this needs to be dismissed now.
Mr. Mathis, is there anything else you wish the court to know?
You guys can't bring anyone forward as far as the injured party. No one was injured. You guys.
Mr. Mathis, I will ask you one more time. The officer is representing the city of Royal Oak. This is not a case alleging physical harm or breach of contract.
Why are you trying to charge me?
This is a civil case under the motor vehicle code as it was decriminalized in 1979. This is a civil matter. The burden of proof is a preponderance of the evidence. The officer has testified as to what he observed, and it is now your turn to testify as to what occurred. There is no requirement under the rules of procedure, civil, in this operation as of today, that requires a quote unquote injured party to be present. The officer has stated very clearly and fairly and plainly what he observed that day. So as to your testimony related to the date in question, is there anything else you would like the court to know?
One ends the way most sovereign citizen encounters do, with the judge maintaining calm professionalism while the defendant walks straight into legal trouble. All he had to do was acknowledge his name, apologize for missing court, and he'd walk out with a new date. Instead, he left with a warrant. And now, as we move to the next sovereign citizen, brace yourself, because this guy's confidence levels are off the charts. Where the first defendant was confused, this next one is convinced he's...
So the evidence, the officer, a duly sworn and certified Michigan peace officer representing the city of Royal Oak, which is one of two cities upon which this court has jurisdiction, has put his testimony forward. There is nothing in the record that has rebutted any of it. Therefore, the court is finding you responsible for the citation as it was written. The fine for that serves $175. That is payable through the pay portal on the 44th District Court website, or you may walk a cash check or charge into the 44th District Court. Please don't interrupt the court, sir. You may walk a cash check or charge into the 44th District Court at 400 East 11 Mile Road, Monday through Friday, between 8:30 and 4:30. That's due within 7 days, Mr. Mathis.
This right here is the core sovereign citizen paradox, demanding rights from a system they claim doesn't exist. The magistrate gives him 3 clear options, but instead of choosing, he claims he only pleads to God. In legal terms, that's a fancy way of saying, I'm about to lose this case. What's fascinating is how composed the judge remains. He's done this dance before. But every minute wasted on this routine is proof that courtroom patience is an underrated superpower. Let's be